everyone, and welcome to this webinar on Force Majeure and COVID. We'll get going shortly. We'll just give people a bit of time to dial in and join us. You should have on the bottom of your control panel, you should have a chat function. It'd be great if you guys can just type in there where you're joining us from. It's always interesting for myself and Terry to know where people are dialing in from. So yeah, feel free to pop in there where you're from and we'll get going with the webinar very shortly. Adelaide, hello to Adelaide friends. SA, we've got a couple of SA, Darwin. It's good to have more from SA rather than the usual suspects of Sydney and Melbourne, so it's good to have some diversity there. Tasmania, hello. Kuala Lumpur, hello to our international audience as well. Wonderful. So I think we'll get going with the webinar now. So hello and welcome to the session on Force Majeure and COVID. My name is Holly Baldwin. I'm from Informa Corporate Learning. I'm delighted to be joined today by Terry Reid. So Terry has over 30 years experience as a solicitor and barrister. He gained his qualifications at the University of Auckland and Melbourne after a stint in the financial sector advising on financial transactions. Terry also lectures at universities and does wide extensive training. He has an exceptional legal mind combined with a great business prowess. So we're very lucky to have Terry with us. This session will probably go for around 15 to 20 minutes in terms of the webinar content. And after that, we will do a Q&A session. So again, please do use the Q&A tabs or the chat tabs on your control panel to ask as many questions as you want throughout the webinar, and we will get to as many of them as we possibly can at the end. So welcome, Terry.
Thanks, Holly, and thanks for that introduction and welcome everybody. A nice opportunity to talk to you a little bit today about force majeure and COVID, and I think often when we look at our contracts, we sort of get an opportunity to see how good they are when we get situations that arise that we weren't necessarily expecting. And I think that this is what COVID-19 has presented, a whole raft of legal issues. As we know, a lot of the steps that have been taken to deal with some of the challenges have been legislative steps. So the government has been proactive in providing support around a number of areas of commerce to ensure some protections. But I think one of the areas that interests me most is, of course, how our contracts are standing up in the light of this difficult situation, in particular, how it's impacting on people's pre-existing contractual duties. And I think that there are a number of areas where COVID is relevant, but today I just want to focus a little on force majeure, mainly because I've had so many questions around the very point of COVID and force majeure and what options that are available to people contractually. And I guess I'm one of those contract practitioners that I'm very keen on ensuring that my destiny is determined by me and not somebody else. So therefore, the contracts and the force majeure clauses that are used, I hope, are tailored for my particular clients and their use. And I think that that's just a point to note here, as we know that the interpretation of all contract clauses is content and context driven, so that I can make some statements about force majeure, I can make some statements and recommendations as things and practices that I think are appropriate and some of the things that I've seen, but your own interpretation will very much depend on your clauses and the content and context that we're taking them in. I think force majeure, I guess the first statement is that it's not a common law creature. It's a creature of civil law, and it's an extremely effective method, I think, of enabling a party or to provide a party with some relief around its contractual obligations where we get this unexpected or external event that actually occurs. So it impacts on the performance both on a short-term or long-term basis, or in fact this event may make the contract quite different than what we actually envisaged. Now, as I said, the common law does not have a principle of force majeure. Yes, judges are now having to interpret force majeure, but if you are wanting to take the advantage of what force majeure provides, then you are going to have a clause that deals with this specifically. So it's not going to be possible to imply a broad force majeure provision into a contract unless you actually state it. So we're looking for the clause, and we're looking at the precise wording of that clause. So generally, for a force majeure clause to prevail, you're going to have a force majeure event that's actually arisen. And then the party is going to have been prevented or impacted in terms of their delivery of the obligations under the contract as a result of that event. Also, the event itself must be beyond the control of the party. So you can't go out and create your own force majeure event to avoid performance of the contract. And then there's the other point that I want to spend a little bit of time talking about is the issue of mitigation and whether or not you need to mitigate the impacts of that particular event. So our first point always with the force majeure clause is to look at the event and how are you describing the event that you want to act against the performance of your obligations under the contract. And I think that there are a number of ways in which you can deal with events and how you describe force majeure in the clauses. So you need to look at your clauses to see how this is done. One way is to simply use some general words. So you might say a particular event beyond the control of the parties that impacts on the performance of the contract. So we're just generally describing the supervening event or the event that we're going to be relying on with regard to the clause itself. Some others in their drafting will provide an exhaustive list of events. So those are, sometimes you see a force majeure clause that can go on for pages because people are in fact listing every event they want to be included as a force majeure event. The third way in which you can draft a force majeure clause is perhaps to have a combination or a hybrid of those two approaches where you will list certain events and then you'll have a sweeper clause or at the end of the clause that says or any other event. So it's not it's more of what I would describe as an open list. So I guess what your preference will be entirely up to you. My preference is in most occasions I like a list, an exhaustive list, and the reason for that is I like to know exactly what matters are going to be covered, and I do not want a third party determining what else might be included. So because I'm suspicious of third parties imposing obligations on me, I like to have an exhaustive list. So you're going to say to me, well, that's fine, but what if your list is not right? Well, if it's not right, it's not right. I haven't read the content properly. I haven't read the context properly. So I guess I have enough faith in my ability to draft and to extract the information from the client and the client knowing what needs to be on that list. So remembering we're looking at events that are beyond our control. So we might have something like an act of God, which is a typical type of expression that we see, or we might break that down. We might talk about earthquakes. We might talk about tsunamis or whatever. But remembering it's the event, it's an event that is going to be relevant to your content and context. Some contracts might just describe force majeure event. Now, because there's no general English law principle of force majeure, and there's not a clear common law definition of force majeure, that doesn't get us very far. So somewhere you're going to have a definition of force majeure. So if you look at what is in your list, we see the list shift over a period of time. I know following a lot of the terrorist attacks in 9/11, we started to get specific reference to terrorist type attacks as force majeure events. And then, of course, more recently, we're focused on some of the challenges that COVID-19 has presented with regard to delivery of contractual obligations. So people go to their force majeure definitions or their lists to see whether or not COVID-19 is classified. So you may have it listed as you may have listed in your list diseases, epidemics, pandemics, right? So, and then if you're thinking, well, COVID-19 is described as a pandemic, so therefore it would fit within the definition. Then a problem, if you haven't got it listed as a disease, epidemic or pandemic, prior to COVID-19, I didn't see one contract that actually listed COVID-19, obviously, right? But you might then rely on something like act of God. Now, the further you move away from defining the event into these broader categories, the harder it is going to be for you to be able to fit COVID-19 into that definition and then rely on the clause to manage your contractual obligations. So the challenge that I have with COVID-19 is that I don't see many instances contractually where the performance of the contract has actually been impacted by the pandemic at all. There's a fundamental causation challenge. Most of the difficulties that people are suffering under because of COVID-19 are brought about by government action or government intervention, right? So the government has locked people down, they've prevented people from traveling, and all of these measures, these are the things that have created the problem. So in a way, if you look at, if I've drafted a clause, I might not have dealt specifically with COVID-19, but what I might deal with is the actions of government that actually make my contract more difficult to perform. And that, I think, gives you a greater standing with regard to enacting or calling on the clause to actually help you out. I think it's going to be very, very hard otherwise. So if you're looking to those sorts of things, government acts or government intervention, that's more likely to stand you in good stead than things like pandemic. Even though it is a pandemic, you're still going to have to make that causal statement. So, and remembering that force majeure is a contractual mechanism. So that's why I'm a great fan of it, because it allows the parties to create their own contractual arrangements if this in fact actually occurs. The alternative without a force majeure clause is, of course, the common law base of frustration. So in that case, the common law would intervene and say the contract's frustrated, and we will deal with that. We can deal with that under the legislation, Frustrated Contracts Act. Once again, unsatisfactory because you're allowing a third party the right to determine, and judges will intervene, and that won't necessarily give us the result that we want. So my advice is always, you must have force majeure, and I do like to have the list approach. So then a few other points about it. What are the consequences, obviously, of force majeure? Well, you need to spell those out in the clause itself, so that if your event actually occurs, then what happens? Typically, you might get a period where the contractual obligations might be suspended. If that goes on for too long a period of time, then you might be able to terminate that contract. So it's going to be the way in which you deal with the event is entirely up to you. But typically, we would see suspension followed by termination, and then think a lot about the unwind that might occur. It's all very well to say, well, the contract's suspended. How are we going to manage in that time? Or the contract is terminated. What do we do with regard to that termination? How do we unwind that? You can feed that once again into the contract to provide greater direction and less chance of third-party interference. The other point that I've mentioned here is the mitigation point. Now, there's a little bit of disagreement around whether or not a party that is suffering because of a force majeure needs to mitigate their position, i.e. take steps to minimize the impact of the force majeure event. Some commentators would say that, that's part and parcel of the force majeure obligations as judges are reading them. Once again, I guess I'm being a little bit more conservative. I would include in my clause a positive obligation to mitigate in the event of an event occurring. So that becomes a contractual obligation to mitigate. Yes, you would still need to determine outside of that what those mitigating steps were. You could put some of those in, but mitigation I like to make also a contractual obligation. And last but not least on this, I think that we also need to be looking at the notice requirements. So what notice requirements are needed with regard to force majeure? I think that if you are going to claim force majeure, so you've got COVID, you can classify it as a government act, it's impacting on your performance, you want to claim force majeure, then you need to provide that notice. So what I also like to do, because I'm not a great fan of relying on judicial notice rules, I would like to have contractual notice rules because I've got control over them. I would put in there how my notice is meant to be. So what it looks like, I might include a form, not necessarily, but if I do include a form of notice, it would be very, very simple. The simpler the better. And then I might set some time limits around the serving of the notice and the way in which it actually needs to be served. So there may also be ongoing notification obligations depending on the type of event that we're dealing with. So in summary, I think that contracts that have force majeure, you are looking first and foremost, if you've got a clause, how does it define the event? Does it define the event in the way that I'm sort of suggesting with regard to COVID? If not, then maybe your future contracts need to include these types of provisions. But remember, using the word pandemic is not necessarily going to assist if in fact there's no strict or no clear causal connection between the pandemic and the failure or the difficulty in performing. Then we would have the list. Then we have, of course, what happens in the event that that force majeure is called, suspension, termination, unwind. Then part of that provision is to deal with the mitigating aspect, your obligation to mitigate in the event of the force majeure, and last but not least, the notice requirements. So I think that it is possible to design a nice clause that would in fact deal with the current situation you're dealing with. Of course, most of you can provide for the future, but you're interested currently in what is going on and whether or not your provisions in fact do cover force majeure and COVID. And I think that we're still unwinding on that. I think judges will still be making their mind up, and I think it'll be some time before we get a lot of clarity around this. But hopefully that gives you some things to be thinking about when you're thinking about what your obligations might be in light of COVID if you have a force majeure provision. Thank you.
Wonderful. Thank you so much, Terry. A very kind of apt topic, as you said, and I think, as you mentioned, a lot of people are kind of in the thick of it now, but it's important to protect yourself for the future as well. Please do stay on the line, everyone. We are going to be doing a Q&A session. So if you do have any questions for Terry, please do use the chat function or the Q&A function, and we'll get to them very shortly. But yes, Terry, if you can just bring back the previous slide. As I mentioned at the beginning, Terry does an awful lot of kind of facilitation and training around this subject. He's got a couple of contract law courses, both at the fundamental and more advanced level coming up. We will send out a recording of this webinar with this information, so don't worry too much about taking it down. But we do offer these courses. Please do get in touch with us if you'd like any more information. And we also, if you have a group of learners, we can also customize and deliver training in-house as well. So let me get to some questions now. We've got one that's come in. So it says, hi Terry, can you please elaborate on how you would tie COVID back to a government act as opposed to a pandemic in a definition of a force majeure event?
Yes, well, the actions that the government have taken have been often the actions that have created contract performance issues, right? So because we've been, our movement has been restricted, that has impacted on the delivery of services or maybe the provision of goods. So your force majeure clause would need to include a statement about government acts or government intervention. I think that I quite like the word government act, so that if we're looking at an act of government which creates a performance challenge for us, or changes the nature of our contract, that would then give rise to it being a force majeure event. So we don't need to think too much about COVID then. We're really thinking about the actions of the government that have caused this problem for us. It's too hard, I think, to connect COVID with contractual performance in almost every case. Because yes, there's been a pandemic, but it is not the pandemic that's created the performance problems. It's the way the government has responded to that. And that's not a criticism, that's just an observation. They've responded in a particular way that they thought best, and which is their right to do, but that's the problem. So just I think in terms of drafting, just keep it simple, keep it plain. Don't get, make it specific but broad enough, if that makes sense. So when you're talking about government acts, I think you've got more of an opportunity of bringing in force majeure into that COVID scenario. And I think a lot of your contracts, if you look at them, may very well have this. I think that what we used to see a lot of was clauses that would use the phrase legislative enactment. So I think I'm okay with that. It's quite specific because it is really talking about enactment of an act, right? I think that would cover, I don't know, the courts haven't sort of elaborated on this, whether that would cover a regulatory position, but I think government act is better.
Yeah, this one's quite similar as well, Terry. It says, wouldn't the government act or restriction be a direct outcome of COVID-19 and not come about otherwise?
Yes, but then you're drawing a connection between COVID, government act, and performance. So what I would say is the government act is actually the intervening cause. So in fact, without the government act, what would have been the impact of COVID? It's the government act that has caused the problem, not COVID. Now, there might be specific contracts that are impacted by COVID, but the majority of contracts that we're seeing would have been okay without the government action.
Yeah.
And remembering that sometimes the impact of the action is in fact an economic impact. So it's a reduction of income or something like that, which makes it a little bit more difficult to deal with.
Very interesting. There's lots of interest around that government act part. It's always a tricky one, I guess, in terms of the government COVID, which is the clause point that you rely on. We have got one more question, but we have got a bit more time. So if anyone else does want to ask a question, please do jump in now. So the next one we've got, Terry says, how do we establish causation for COVID, i.e. force majeure event in terms of evidence, substantiations, etc.?
Yeah, that's a good question. You would have to show on whatever fact basis or facts you have that in fact this event has caused this problem, right? And it couldn't be lots of other things as well. So to rely on the force majeure event, you're going to have to see that there's a direct correlation or a direct causal connection between that particular description of cause and the suffering that you're having to deal with. Just one thing to think a little bit about, and we're all sort of crystal ball gazing a little bit here, but so now the government's sort of pushing vaccinations. So I think you've also now got to start thinking about, well, what happens, and we see this government policy is shifting all of the time on this, and now we're starting to get this discussion about, passports, vaccine passports and all of this sort of stuff. Well, for some, this could very well still impact on your contracts. So even going forward, you've got to make sure that you are providing for these sorts of things. Now, I don't know whether we want to start dealing with, vaccines and the distinguishing points here. I think that sort of thing, once again, would be covered by a statement about government intervention or government act.
Yeah, we have had one more come in actually, Terry. This one says, how does one go about working around possible non-performance if the term is silent and the other party does not recognise COVID falling under force majeure?
Well, I guess in that case, you've just got a clear dispute about about the interpretation and the enforcement. I think and it's sort of connected a bit to the earlier question. If you can clearly show on the evidence and the facts that you can present that this particular event has caused this particular problem, that should bring I think a strong enough link for you to be able to sort of rely on the clause. But yes, it's an interesting point. It's all very well to sort of call force majeure, but maybe it's not force majeure at all. It's just, poor performance by the contractor. But I think that if you've got all of those, you've got the mitigation point and you've got your descriptions, I think with a good well-rounded drafting of the provision, you'll be able to distinguish quite clearly between poor performance and a clause that provides for the protection, in this case around the event.
Perfect. Well, thank you, Terry. That does appear to be all the questions we have for this session. So thanks for everyone for joining us on the line and getting involved with the questions and letting us know where you're dialing in from. It's been brilliant to have you all here with us. We do have another webinar coming up with Terry next week, so look out for some more information on that. And as mentioned, we will send out a recording of this webinar and more information on the courses Terry runs as well. But yeah, thank you for your time. And the last big thanks goes to you, Terry. Thank you so much. It's been a really interesting topic. It's obviously stirred some debate. So many thanks for your time.
Okay. Thank you, everyone.
Wonderful. Thank you. Bye-bye.
Bye. Bye.